Hi, I'm Greg Dell here with attorney Frank Darras, and we're going to talk today about long-term disability claims and bad faith. And Frank, as we were talking before we got on film, almost every potential client who calls and asks about a claim when they've been denied, they say, my insurance company acted in bad faith. I want to sue them for bad faith and everything else I can get out of them. But as you know, not every claim is a bad faith claim because you're going to tell us all about bad faith today. So talk for a little bit about so people understand, and let's keep it real basic for people because you know if there's a bad faith claim, we're going to hunt it out and do everything we can to pursue it. But unfortunately, not every claim is a bad faith claim. So let's talk about first the basics of what is a bad faith claim.
Sure. First and foremost, you have to have an individual disability policy, a policy that you purchase from an agent or a broker, or if you got your coverage from work, if you got it and you work for a government, school, or a church, oftentimes we can frame a bad faith claim that way. And bad faith is just the unreasonable or without proper cause, delay or denial of benefits. We all as insureds buy peace of mind and security, and that's not something you can see. That's something that we test when the carrier gets our claim. Do they look at the claim with an eye towards payment? Do they investigate the claim and not make us make duplicative requests of information? Are they fairly looking at our claim? Do they treat us the same as they would treat their own financial interests? Those are the things that after almost 40 years of litigating bad faith claims, I look at.
Okay, so you brought up something interesting right out of the bat, and you said, well, first of all, it has to be an individual disability policy. So does individual disability policy cover the people who get their benefits as an employee benefit?
It can if you work for a government, a school, or a church. So you're a fireman, you work as a maintenance worker for your local municipality. Those are exempt from what we call ERISA, the Employment Retirement Income Security Act, a law that's been on the books since the early 70s. My acronym, everything rotten invented since Adam. So if you've got group coverage through work and you don't work for a government, school, or a church, it's very likely you do not have the right to sue for bad faith.
Okay, so in the simplest form, the most people who have an employer-provided benefit policy are not going to be able to pursue a bad faith claim.
Correct.
Okay. And then you went on and talked about, I guess, the elements of a bad faith claim, but I want to break it down a little bit more. How many elements, when you think about it, are there 1, 2, or 3 core elements of a bad faith claim? What really makes up a bad faith claim other than just saying, my claim was denied and they're dead wrong?
Sure. So first and foremost, you've got to make your claim. You've got to put a bad faith frame around your contract claim. So first and foremost, are you insured properly? Is there a pre-existing condition that's going to let an insurance company off the hook? Is there a problem with the application? Did the carrier say you misrepresented or you exaggerated or didn't give them proper information about your medical, occupational, or financial information? If we get over those 2 hurdles, now we're into the claim. Is my doctor supporting my claim? Do I have good evidence that shows I can't do the important, the material, and the substantial duties of my occupation? And if my doctor supports me and I've got the proper care, the frequency, the intensity, and the treatment that warrants someone disabled, then yeah, we've got the basis of a legitimate payable claim. Now, let's get to the bad faith. Is it unreasonable? Is it without proper cause? What did they do to hurt or to harm? Usually I look at evil, vile, loathsome, despicable conduct, or an institutional practice where, Greg, they say, hey, look, we're going to put everybody through the denial machine. We're going to make it difficult. We're going to make it hard. We're going to bash, trash, and try and make hash out of our insureds. Those things, for me, I look at and say, that's unreasonable. It's without proper cause.
So I want to, for over 45 years, you've handled, thousands of bad faith claims and investigated probably tens of thousands of them. what's an example in the history that comes to mind that somebody could relate to, a fact pattern that you would say that was bad faith conduct, totally obvious, and the court agreed or whatever, it was the company accepted responsibility. And you don't have to name the company if there was confidentiality or whatever, but what would be a factual example?
So I have a back problem, and my orthopedist says I've got objective evidence, an MRI, an X-ray, a CT scan that shows I've got a real problem with my spine. I can't bend, I can't lift, stoop, push, pull, carry. My doctor is board certified in his specialty. And he says, Frank, you tried. You got the right care, you got the right treatment, you took the right medications, and unfortunately, you can't do the important duties of your job. The insurance company should look at my doctor's qualification. They should investigate his background, education, training, experience. Look at his curriculum vitae, Greg, so that we can compare. What did the insurance company do? They hired a podiatrist. What's a foot doctor got to do with my back? Or they bring a general practitioner in to evaluate my claim when I've got a board-certified orthopedic doctor. That's unreasonable. That's without proper cause. That's what can make a jury mad. Because remember, when we're talking to a jury, everybody pays rich premiums for this kind of coverage. And we're supposed to be treated fairly. We're supposed to be paid timely. They shouldn't make us wait.
What do you have to do in your role as an attorney to prove bad faith? And I know it's going to vary on the facts of each case, but generally, what do you have to do in order to go through the process of presenting to a jury, like you just mentioned, bad faith conduct of an insurance company?
Sure. So, in a perfect world, we're in the claim from the beginning. And what I see now, 40 years later, is insurance companies putting the high intensity lamp on the initial claim application documents. So those documents are tricky, they're confusing, and the insurance company takes advantage of us. Why is the box so small, Greg, when it asks for my symptoms or my problems or my inability to do my work? Well, they make the box small so that we can't put, I'm sick, I can't focus and concentrate, I can't get to sleep, I can't wake up refreshed from sleep, my medications make me loopy. The box is so small, but they pick the salt out of the pepper to try and create delay. And when they delay, they're hanging on to our benefits. So, what does a great bad faith lawyer do? There aren't very many really great bad faith lawyers in our country. Why? Because ERISA group policies dominate the landscape of disability, and individual policies where you buy it from an agent or broker have to be framed properly. I mentioned earlier, you got to put a bad faith frame around the contract claim. What can I do as a bad faith lawyer? Number one, I sue them. I sue them early and I sue them often, because if they delay and you let them get away with it, that time where you've lost the money is, you can't get that back. How am I going to get the right care? How am I going to get the right treatment? How am I going to pay for my medication? How am I going to get the things I need to get better if they slow pay, no pay, and they don't give me my benefits? So number one, I have to sue them. Number two, I'm going to be in a court that most lawyers are unfamiliar with, federal court. Why? Because the insurance company is usually a citizen outside my state. So if I'm in Florida, rare we're going to see a disability insurer that's a Florida resident. They're in New York. They're back east. So I've got to sue them in federal court. I got to get the claim file. What's the claim file? That's everything from the application through my initial claim presentation, everything that they did or didn't do. And then I got to get on an airplane, Greg. I need to go to the home office. And I guess if I'm helping people today evaluate your lawyer, when was the last time they were at the home office? I've probably taken 5,000 home office depositions. A carrier respects that. You're going to go there for 4 or 5 days and start at the bottom, the claim person, the consultant, the manager, claim manager, the vice president of claims, We're going to depose the vocational people. We're going to tear apart the doctors that they brought to look at the claim. And then we're going to try and put the black hat, the bad faith hat, on whoever didn't do well. I never have an idea before I go who's going to wear the black hat. But boy, oh boy, after 5 or 6 days at the home office, it's pretty apparent who was unreasonable.
So just so people understand, you get the opportunity, or any of your lawyers working with you, to go there and take a deposition. And some people may not even know what that is, but basically what that is you get to question them under oath for 4 to 8 hours, depending about as long as you want, and ask them anything and everything about the company, how they administer things, what their claim handling procedures are, what did they do on this claim, and learn everything so that you can help establish your case to show that their conduct was unreasonable and not consistent with how a claim should be handled. And you can explain basically that you always find, I call them nuggets of information, to basically where they almost make an admission. That you basically say you are dead to rights now because you just admitted that you did it wrong. And often I find from having taken so many of those depositions that they just don't know. I say they don't know. They probably did it intentionally, but they don't know because they didn't have proper training, teaching, or whatever it is. Or they do know, and upper level management, which is more common the case, said you need to do it this way.
Usually what I see today is very compartmentalized roles. So the claim person, the average insured thinks that the claim person has a real keen understanding of the medical. They investigated the important material and substantial duties of the insured, either in time spent or money earned. Not the case. The claim examiner is not looking at generally a curriculum vitae or a bio of the insured. They should. If you're supposed to investigate the important duties of my occupation, how do you not know how I spend my day in a working way?
Right.
Or if my doctor is board certified and you're on-site doctors, that's one of the hot areas for us in bad faith. I love taking the depositions of the doctors that are on staff at the home office. Why? They haven't seen a real live patient in 20 years. The only prescriptions they write are for themselves or their family. They no longer have an office. They don't have malpractice insurance. They're a vice president. And I say, do you have your own parking spot here at the company? You've got a vice president slot,
right,
very close, but you don't see patients, you don't evaluate patients, you don't have any malpractice. You haven't last seen anybody with this condition for 10, 15, 20 years. That's wrong. I've got a treating doctor who every day goes to the office, sees real live patients just like my insureds. They hospitalize those patients. They're in the hospital. They make rounds. They're prescribing medication. They're interpreting results. Not like insurance company doctors. Greg, oftentimes I see they're the king of no. Not enough treatment. Not enough care. Oh, gee, Frank, we wish we could have paid him, but he didn't use enough medications. Oh, gee, Frank, if he'd only gotten an MRI. Really? An MRI is $2,500. If you don't pay me my benefits, how am I going to support my medications, the testing that proves I'm disabled? If you slow pay me, it's a sure road to a denial.
So there's lots of things to explore, and like you said, when you go in there, you're not sure who's going to be the biggest culprit. It could be all of them, it could be one of them, it could be two of them, but it's always fun from our perspective, I mean, to go in there knowing that, look, they don't get deposed all the time, so they're scared, they're always dealing in volume, and now they got to be dialed in on this one case, and if they didn't handle it right, we're going to prove that they didn't. So that...
And we're always videotaping.
Yeah.
I videotape every one of my claim depositions because oftentimes they do so poorly, they're not anticipating that you'd spend the extra money to videotape the depositions. I mean, I can usually do 3 or 4 or 5 depositions in a day. We've got a great videographer. We've got a court reporter that's taken down all the words that are being said. We've got a claim file. A seasoned bad faith lawyer knows exactly what the insurance company did, and they do it in a claim file. If it's not in the claim file, we always say it didn't happen. So how do they communicate? Do they communicate in a message, WhatsApp, text messaging? You know, there's a lot of ways an insurance company people can communicate amongst themselves. Oftentimes it's not in the claim file. And for the average insured, to get the claim file is a major accomplishment. Then you've got to plan the trip, go to the home office, depose the people, get a local court reporter, and how long are you going to stay? For me, it's usually Thursday, Friday, Monday, Tuesday. They're like, dang it, Frank, now we've got to put up our defense lawyer over the weekend to come back on a Monday or Tuesday. Well, of course. Why not, if you're going to the home office all the time like I do, why not do it in a way where it's hard for the insurance company? You know, they got to pay the defense lawyer to spend the weekend there because we're coming back on Monday and Tuesday. Great. They're going to remember us.
And these cases do get expensive, obviously, to litigate. The cost of depositions, the cost of travel, the time, and all of that works in the favor of the claimant, in my opinion, because having done this thousands of times through our law firms against them, they know to say, hey, this is going to cost us a good 6 figures, over $100,000 to defend this case, no matter what. Do we want to go down this road? Do we really want to let them come into our office and depose all of our people and expose everything we're doing here? And that's another advantage, especially in working with our law firms, because every single company knows we know what we're doing, and we know we're going to hold your feet to the fire, and we could expose your entire practices, which isn't only going to affect this claim, but every other claim that you've possibly handled. Because once we take these depositions, more often than not, or if it goes to court, can be public record.
The difficulty for most plaintiff firms is that they're small. You know, 2, 3, 4 lawyers. You know, we've got a herd of talented, aggressive, centered lawyers where it's not the money that motivates our lawyers in our law firm. It's doing good by doing right. You know, taking that person that's been cheated or has had their benefits withheld wrongfully and being able to uncover and to prove why the insurance company, you know, I often say, gee whiz, if I rob a bank and 10 years later I bring the money back, and I said, why is everybody so upset? I brought you the money back after 10 years. There's got to be a consequence for the wrongful or unreasonable delay. So if I can prove that it's unreasonable, if I can show that they didn't do a fair job, they didn't investigate with an eye towards payment, they didn't put my financial interests of my insured first, that's something that a jury is going to resonate with. Look, we all pay rich premiums. If I said to the insurance company next month, Greg, well, you know what? I'm not sure I want to pay this month's premium. I want to look at some more information. And I said, you know, send me the information. Dang it, Greg, I lost the information. Or it's missing. Can you send that information again? Can you imagine the organized chaos that would create?
Right.
Insurance companies want to get paid on time, every time. And God forbid you don't make a payment. Now your policy lapses. And that's the way it should be in a disability claim. I paid for you to treat me fairly. Don't you dare cheat me or create some institutional hurdles, claim bumps, stop signs. Interpret the policy the way it was written. Don't have some hidden agenda or some secret way that you're going to evaluate my claim. That's not fair. That's not right. And you know what? Juries get angry about that because we're all insureds and we all pay too much for our policies and our premiums.
Right.
The least they can do is treat us fairly.
Well, thank you for giving us this brief summary. In other videos, we'll talk about damages, which we didn't even touch on this video, but wanted to give people the general understanding to say, hey, do I have a bad faith claim? What are some of the elements of what it is? And really, most importantly for people out there is reach out to us. We always provide a free consultation. We can let them know pretty quickly if it's something that is worthy of even looking into further, because it does require an investigation. It's not just going to be told over the phone, but we know right away, is it even worth taking the next step? So if you're someone out there who has a private long-term disability claim, feel free to reach out to Frank, myself, any of our disability lawyers, no matter where you live in the country. We're available to assist you, and we always provide an initial free consultation.